Bill, thank you for sharing your time and expertise with us on nuclear verdicts, one of the biggest topics going on today. One place I want to start, and I've done this with the other folks I've talked to, is how do you define a nuclear verdict?
I don't think there's really a definition. I think it's really in the eyes of the beholder. You know, everybody goes back to the 1994 McDonald's coffee verdict. Oh, wow, that's a nuclear verdict. That was only $3 million that ended up really being overturned. But people thought it was kind of ludicrous because of the nature of it wasn't really the amount of money. And so I have clients that have been hit for $5 million. They consider that a nuclear verdict in their world. And then you go talk to a company like Walmart, you hit them for $5 million, they're laughing all the way to the bank. So I think it's really dependent upon the industry. But I think in general, we could all agree that the nuclear verdict, or what we would call this 30 years ago or 25 years ago, the runaway jury, these are just verdicts that are very outside of the original economic assessment of the case.
You know, how did we get here, Bill? To build up to this, and I spoke with Rebecca Brewster about the ATRI study, and they have the charts that track out the increasing verdicts over time and then increasing sharply lately. How do you see us getting to this point in the progression of this?
I don't think it's anything new. This phenomenon's been around for a while, Doug. This is not anything new. Everybody's making it new. And I think between media, social media, the plaintiff attorney advertising, it's getting a lot more attention. But this is something that's literally been around for 30 years. And yes, you have these very high verdicts, but you start going back into the 1980s is when this started happening. So again, this is nothing new, but there are various factors that we go over in this paper. We know what causes this stuff. Unfortunately, you have a lot of pundits out there that have many hypotheses, and they're only hypotheses, about why this stuff is happening. For example, jurors are fed up. Jurors are fed up. Well, jurors were fed up in 1982. I can tell you that much. And they were fed up in 2002, and they're going to be fed up in 2022. This is nothing new. So what we've tried to do at Courtroom Sciences is really focus on the scientific predictors of what's going on here. And over a 30-year period, we've really figured that out.
Let's start. One of the things that I think you begin in the article with and lay out, and is very helpful to folks, is the various causes that can be for and I call them detonators, to detonate the verdicts. What if you want to go through? Yep, exactly. If you want to go through those, Bill, in terms of what you had from the problem witnesses, egregious conduct on down through those.
Yeah, and number one on that list, and it's a reason for number one, because it's by far the number one predictor of not just verdicts but damages, is the quality of the witness testimony from the defendant. Number one predictor of verdict and damages, which is why I'm so busy preparing witnesses every week for deposition and trial testimony. And I think one of the factors that's really played into this is the fact, especially over the last 20 years, is the number of, particularly with corporate rep, but just any defendant fact witness, the number of these depositions that have been videotaped and then used in the courtroom, 2 years later. Can have devastating effects, number one. But then just the live testimony, and what the plaintiff bar has done very well is learn how to completely take advantage and manipulate witnesses and get them into more of these kind of fight or flight response patterns. And juries don't like that crap. They really, really don't, Doug. And so if and expert witnesses on most cases, they kind of cancel each other out because they're all hired guns. Everybody knows it, but the fact witnesses were there. So the problem witnesses for defendants really seal the deal very quickly on liability. And then we start talking about nuclear verdicts, the more dislikable these people are, and the lack of trust, the lack of believability, some sense of sliminess even perhaps. This is what gets juries really out of control with those dollar figures. And so that's really the top factor pushing this, which, by the way, highly preventable and highly controllable.
I was going to say, Bill, you in courtroom science deal with this all the time. What are we talking? The demeanor, the content, presentation, or all of the above?
It's less content. It's more of the it's more of the, so you got your demeanor, which is just the body language, the professionalism. You would think, you tell any witness, hey, be professional in front of the jury. Well, if you're particularly if you're a witness that's never testified before, and you're going into a foreign land, which is a courtroom, you're nervous, you're anxious, maybe you're frustrated for being there. And a lot of that demeanor can really go south pretty quickly because of the emotional side of this. So that's definitely a factor. I think the number one variable, though, is emotion. Again, back to fight or flight. Witnesses will become very defensive and argumentative, if not evasive. Huge turnoff to a jury, right? Or on the other end, they do the opposite. They, rather than arguing and fighting, they go, okay, all right, I'll say anything to get out of this chair right now. No limit to the Kennedy assassination to get out of this. And so the emotional aspect is the number one factor I deal with witnesses, but that is really what's driving the poor testimony.
In terms of the witnesses, we talked about that. One of the other factors I think you indicated was the egregiousness of the conduct. And you go from the, what for a lot of people was a punchline, the McDonald's jury, until you start to drill down through it.
Oh, yeah. They completely played that case the wrong way. And when you have, so here's an uncontrollable factor, Doug. See, I can control witness testimony. I can control that. I can't control it when you have, terrible emails, right? Or your hiring practices, right? So, for example, in the trucking industry, some of the hiring practices, you're like, I don't know about that. Or if you have a defendant that was intoxicated on some sort of drug, right? I mean, there are certain areas here that when a jury hears it, they cringe and they want to go into a punitive Sunday message type of nature. And the way that type of cases, those cases aren't designed for courtrooms, Doug, because it's not a matter of, are you going to lose or not? It's yes, you're going to get your butt handed to you. It's just a factor of how much. And so when you have these cases where you have egregious conduct that we know is really going to tick off a jury, kind of how the trial attorney works up that case, you're trying to mitigate and probably resolve that case well before it gets to the courtroom. Because when jurors see that stuff, particularly in the form, especially now in 2020, electronic communication, pictures, videos, this is stuff the jury cannot unsee. And so I think it's very important that these cases get properly assessed and worked up initially to really position them for settlement. Because if you get into a courtroom, the jury will never forgive you for some of this stuff.
Is it a situation we talked about, Rebecca, in the Atri study about this, where one of the key ways to avoid the nuclear verdict is to evaluate what you have early on and make your strategy, make your call then, rather than play your hand and see what happens?
Yeah, in fact, I mean, maybe that's the top factor in avoiding nuclear verdicts is being aggressive early in the case, even if it's a bad case. The defense bar and quite accurate, gets criticized for being more reactive than proactive as compared to the plaintiff's bar, and that really has to change. And so, yes, accurate assessment of these cases early on, absolutely vital to suppressing nuclear verdicts. But then the next step being in discovery, who's going to be taking the lead here? Who's going to be driving the momentum? Are you going to be reactive or proactive? And so a lot of what we do is, collaborating with our corporate clients, with our insurance clients, to ensure that these depositions, right, don't blow up in our face, because that's what's going to start multiplying the value of the case. And even if you have a bad set of case facts, you have relatively effective depositions where the plaintiff attorney is not leaving the deposition really with more than they came in with. They're not reptiling, your witnesses. You can really suppress the value of that case, and it can be a resolution that's fair to both parties. You do the opposite. That's how no one talks about the nuclear settlement. That's actually the bigger problem here. The more expensive problem in this industry, well, all industries, but just in litigation, is the nuclear settlement that never reaches the newspaper, that no one wants to talk about. And that's what's happening here. Because listen, 98% of these cases settled, Doug. Just as well as I do. Yeah. You got 2%, getting on the newspaper, getting on the internet, and you're seeing your nuclear verdicts, and that's what everybody's worried about. It's the 98% of the settlements where there's a lot of money being completely wasted.
Well, kind of jumping ahead a little bit, I think that goes to one of the other topics you brought up in the article, and it's right out of the pages of Reptile, is to play upon the risk aversion of either the defense bar or the insurance companies, and the impact. I mean, my saying always is that that insurer can justify a large settlement. They can't defend an explosion on their watch. And in the Reptile, it tells them to play upon the career-ending potential of a large verdict to a defense attorney.
Oh, there's a full chapter on this in the Reptile book. And this is why what you're seeing is, I was working on a case last year in Atlanta on a slip and fall in the grocery store, where the lady didn't slip and fall. She tripped and fell over, wearing a $2 pair of flip-flops, and was clumsy and tripped and fell and broke her leg. And the whole thing's on video. Doug, the demand on the case is $15 million.
Yeah, well,
Here's the thing. And we actually had a great outcome in this case because of all the work we put in. But here's what they were betting. Like, hey, I know this case ain't going to trial. What? Yeah, I know this is not even a $500,000 case. I can throw out $15 million because now I got everybody nervous, right, in-house. And now the excess provider's calling, going, uh-oh, what's going on? I've got everybody in a frenzy. And the only thing that's going to get rid of this case is somebody writing me a check. And I don't care if it's for half of the 15. And so what you're seeing now is this exploitation. And boy, this is so bad. And it works. Hey, hats off to the plaintiff's bar. They're completely exploiting the system and using the leverage. And you're right. They call it the ever-present guillotine of the profession, where if I get hit with a verdict, I'm getting my head's getting chopped up. And if I write this check, it may not look good, but at least I'm not losing my job. It's happening from coast to coast, all 50 states.
Yeah. You said about being aggressive. Some of the things we do, Bill, and I kind of get startled reactions from insurers, and they eventually accept it, is a lot of times if we have a potential claim on liability, we'll sue the other side first, get us to jump on discovery, and also to hold jurisdiction. Before suit's filed, we'll ask for independent medical exams. And I really don't care if they accept or not. I've got them on record. If they deny it, then it puts them in the background on that, and push back right away on this. Anything else you see or that can be done to take the fight to them? Because you're right, too often I see cases where people have just sat back, or they'll do an initial investigation, put it in the file, and wait until the attack comes to them.
Yeah, I mean, the best attorneys I work with, this is going to sound insane. It's going to sound absolutely insane. It's quite brilliant, actually. The best attorneys I work with across all industries, whether it be trucking, healthcare, product liability, Doug, they start writing their opening statement in the first month of this.
Well, I do my closing statement that way.
Yeah.
And write the closing statement, and then it's what facts do I have, and what facts do I want to develop to argue to the jury, and that's the focus of the whole case. You're absolutely right. Yeah.
So step number one is start preparing this case for trial the moment it's filed and you start getting your facts. Number two, which is what I find quite fascinating, which I'm very happy to report this, is when I started in this field roughly 16 years ago, every mock trial I conducted, every focus group I conducted was within a couple months of trial.
Right.
Get ready for this. 7 out of 10 mock trials and focus groups I do now are in discovery. They're before mediation. Right. Now think about this.
Yeah.
Listen, you want to avoid a nuclear verdict? How about figuring out you have a nuclear verdict on your hands first? And yes, that's going to cost you $50,000 to $150,000 to properly do the jury research. But if you're a claims person or in-house counsel, trial attorney, and I tell you as a clinical neuropsychologist and jury scientist, I tell you, hey, your case is worth $100 million. A jury is willing to award $100 million. And I tell you that 2 months before trial. What can I possibly do for? I can give you a blindfold and a cigarette, Doug. That's as best I can do. If I tell you you have a nuclear verdict 3 years before trial, you see the point here?
Oh.
So I really think it's not just the thought process of preparing for trial. It's doing the scientific homework to actually figure out the value of the case. And by the way, how do most companies, particularly insurance companies, figure out the value of their case? They ask the attorney, so what do you think this case is worth?
Right.
And the attorney goes, well, this case is worth 5 and 10 million. I'm going, hello, where in the world are you getting these numbers from? So another reason why nuclear verdicts happen is really a misassessment, bad assessment choices early, and a lot of hunches about what a case is actually worth, rather than putting the time, energy, and yes, money into jury science to figure out what the case is actually worth.
And I think that was one of the key takeaways I got from your article, the analogy of the tourist from Turkmenistan.
Nobody wants to do
it. Because you don't hear about that because no one goes to Turkmenistan. In terms of the jury science, the lack of people who do that, or cases that do that, you want to go into that in terms of the application and the importance, Bill, of applying scientific evaluation as a means of avoiding the nuclear verdict.
It works. It works. But the problem is, which has been the 30-year problem, or it's before my time, is that the insurance defense industry, the claims people and the indemnity people, these are two different people. They don't talk to each other. And the claims person is getting paid and bonused on spending the least amount of money possible on a file. They have no financial motivation to win, right? And so it's the barrier here is one of financial. Because listen, Doug, if I told you, Doug, if you give me $100,000 cash right now, I can prevent you from losing $50 million. Would that be a good financial deal? You'd be like, where do I sign up?
Incredible ROI.
Yeah, it's a credible ROI. But the problem is the insurance folks don't assess it that way. They see it as a loss because they have to spend something. Yeah. Now, quite frankly, the the corporate in-house folks, they see it as an investment. Yeah. And so when I'm actually working with a company that has an SIR that's significant, and they're paying the first 10 million, it's amazing how the mindset changes, and they're willing to put up that, whether it be $50, $100, $200,000 to do their homework up front to avoid that $50 million verdict. Whereas, the AIGs of the world, these kind of just the generic insurance companies, they complain about every nickel you spend on the expert, on the mock trial, on the witness prep. And that's what sets themselves up for disaster.
In terms of the cases to apply the science to and start early, not every case would lend itself to that, but what are the cases that you would say, those are the ones we should flag to start this process earlier, sooner than later on this?
Well, it's not, there's, you have your obvious variables, right. Catastrophic injury, right? Death, particularly something that's gotten a lot of media attention. Right. I think, and by the way, people die. There are accidents every hour in this country. That's not the major. But it is more the egregious conduct stuff that you better get ahead of. So one of my new specialties, which will not come as a surprise to you, are municipalities hiring me on police brutality cases, because now everything's on this, chest cam, right? Just like in trucking, you have your dash cam. And so, for example, so when you have cases where, everything's, when you go into medical malpractice, nothing's on video. There's no video of the heart surgery that they botched, right? But in trucking, everything's on video now. Transportation as a whole, if you're a municipality and you have a bus or a train, there's video everywhere. All the police officers are wearing video. These are the types of cases where, I got up early, dragged my butt out of bed for you, Doug, by the way.
I appreciate it. Thank you.
I put on the news, and the only thing I see is video trying to get voters upset. Which, by the way, who are the voters? Oh, they're your jurors. They're the same damn people. And so anything that has visual stimuli that is controversial, negative, shocking, these are the things. You talk about nuclear verdict. I don't even know what the word above nuclear is. Yeah. Thermonuclear, I don't know. But I think that's where you see some kind of even crazier than we've seen, is where you have these cases that have video/audio of very bad things happening, which really drives a lot of emotion. That's what you see. And politics is driving this right now, but so is the plaintiff's bar, and it works on both ends.
Well, and one of the things I say is we live in a YouTube society.
Yep.
In terms of everything being on videotape, we're assuming it is down to the Ring doorbell videos that we have.
Crazy.
It kind of leads into a question: what do you do about it? You have, let's say in trucking, we've got a egregious video, particularly one that the two-way videos where we have a driver who is engaged in conduct that he shouldn't be, texting or something like that. What can you do, Bill, from the perspective, or how do you deal with the worst of the video evidence that is going to inflame a jury?
Well, we can't change facts.
Right.
Say that. Can't change facts. Test it with a mock jury to see, is there any way to get around this, explain it, mitigate it, right? And do that as early as possible. And again, what you're trying to do is resolve the case. The problem we have, which again, hats off to the plaintiff's bar, they have figured out when not to settle. So you finally figure out, okay, we're screwed. We are so screwed. And then you go to plaintiff's counsel's, okay, that check for 25, was it 25 million? Okay, and they, oh, no. Oh, no. Now it's 50.
Yeah.
We're going to see you in court. They've learned how to play poker really, really well. And the problem is you have some of these cases that are just indefensible because of the egregious conduct. And there is what you're trying to do is you're really trying to put pressure on the actual plaintiff to say, hey, I got a big wad of money here.
Yeah.
You know, why wait 2 more years to get your money? I got the money right here. You'd be shocked how many people would rather take the money and not go to trial. And so I think being aggressive early with settlement negotiations and being more than fair to try to resolve the cases. But I have a client, which should go unnamed, out west, right? And they had injured somebody. One of their folks was driving a company vehicle, crashed into this person who was on a motorcycle.
Mm-hmm.
They suffered some really, really bad injuries. Doug, they went out and bought this guy a house.
Yeah.
They bought him a wheelchair van, right? And said, hey, we will do anything. You know, we'll do it. Right. We'll do the right thing here to avoid the litigation. And if it actually worked, but rarely do you see such behavior. But you'd be shocked how often when you have all this anger in this country, when somebody finally does the right thing, you'd be shocked how the impact it has on your adversary.
Sure. You know, one of the big things you wrote about in the article was the predictive element of it, using scientific to do it. You want to talk about that a little bit, Bill, please?
Well, yeah. So using the scientific method to predict this stuff. And again, the vast majority of case values are assessed on hunches or previous verdicts in the venue, which don't work. That's not how science works. So it's the methodology that's put in place. Unfortunately, in my industry, unlike yours, we are unregulated. I'm probably one of the few people in the jury consulting industry that actually has a PhD in behavioral science and I've actually done scientific research and been published. And so I'm very strong on the scientific method of doing the research correctly to ensure a valid and reliable result versus a lot of people in this industry. They have a bachelor's degree in political science. By the way, political science is not a science, Doug. I just want to make that clear.
As a political science major, Bill, I know that. So thank you. Thank you for reminding me.
But even if it's a master's degree in anthropology, or even my favorite competitors, the former trial attorney that's no longer practicing law, but now they're a jury consultant. They have no training in the scientific method. So it's the how are you going to put on the stimuli for the mock jurors to what is that going to look like? Well, there's a certain way you have to do that, which one's scientific, one's very unscientific, right? So I know the science behind that. And then your data collection and analysis. What type of data are you collecting? Is it questionnaire? Is it oral? Is it a combination? And then finally, how are you analyzing that data? So one of the key mistakes, which I'll give you this, I don't think we put this in the paper, but we have something called a severity shift, where say you have a mock jury with 24 jurors. The mistake to make statistically is to poll all 24 juries and say, okay, on compensatory damages, how much do you award? And then on punitives, how much do you award? And you take all those and you make a chart. And then you take the average of those and then you go to your client, right? That's the completely wrong way to do that. And anybody with any type of scientific background would know you don't do that. But your average Joe, that's the way they do it. You get very misleading results. What you do is you break that group of 24 into 3 groups of 8, and you have the jury come up with group decisions. And then you get 3 sets of data, group 1, group 2, group 3. You average those 3 numbers. That's how you'll get an accurate damages forecasting of your case versus taking all 24. So you can see how statistics.
Right.
Again, you see it every day. Look at the COVID numbers. I mean, there's a fight about COVID numbers every single day because people politically, of course, are arguing about these statistics. Well, the same thing happens in jury science is if you don't know what you're doing, you get some very misleading values, which then will mislead your client. I think that's kind of unethical and inappropriate, but it happens all the time.
In applying that scientific method, you described in your article what you're looking at in terms of, and the usefulness, as you said, most cases don't end up going to trial, 98% settle. So the usefulness of this data in terms of your parameters for settlement, Bill.
Well, we have many clients that will enter a mediation with our report, going to the mediator saying, hey, we hired people with PhDs in behavioral science. Here's the sample that they recruited. Here's what we showed them. Here are the results, meaning this is roughly a $5 to $8 million case. It's not the $55 million case that they're demanding. And we have scientific proof. And that has worked very, very often in mediation and negotiations. Now what's going to happen, unfortunately, is that your plaintiff attorney is going to be like, well, I did a mock trial too, and the results came back at $100 million. But then when you start digging into the plaintiff attorney, see, here's the one thing. Plaintiffs do more mock trials than defense, but they do them really badly. Mm-hmm. Yeah. They invite their neighbors over for pizza. Hey, let's talk about this case. And that's how they get this. So it's very unscientific. But then when the mediator starts to see the science versus the lack of science, I think it can really compel a mediator to take your side. So I think building that case for mediation / settlement is very important, using the science. But probably, back to the guillotine, the head rolling thing. If I'm a claims adjuster, before I go settling a case for something ridiculous, I'd probably want to go to my boss with some scientific evidence of, here's why I want to write this check and get approval, because I know if we go forward, we're gonna lose big and it's gonna cost a lot of money. Here's why I want to write this check, and I have proof that writing this check's actually gonna really actually save us a lot of money in the end.
Shifting gears, Bill. One of the things I think you talk about in the article was the geographic impact of the potential for a nuclear verdict, judicial hellholes. Thoughts on that?
Yeah, well, everybody's calling me right now saying, well, what's the impact of COVID and social unrest going to be on jury decision making? And we're actually collecting data on that now. I can tell you this just generally right now, it's not positive. It's not a positive thing, right? When you have a jury pool that's been devastated economically, emotionally, mentally, that's not good for defendants in a courtroom. I can tell you that. We will continue to talk about that. But whether you have COVID or not, things like social unrest in, well, close to you, Philadelphia, right, Baltimore, Los Angeles, Atlanta. I mean, I can go on and on. You get cases in those venues, you're kind of behind the eight ball. And you have to be very, very careful, because regardless of the facts of the case, you have a jury pool that wants to settle a score. And that's not going to change. And I think that's actually going to multiply and get worse. And so, again, what can you do? Again, early assessment, doing those things to figure out which one's my nuclear verdict. But in those types of venues, there's not a lot that can be done, because not only are the jurors oftentimes very your judge, your judge is going to roll against you on every motion, and now you have 2/3 of the pie against you. Bad situation to be in, and those are those are the types of cases that you want to try to resolve as early as possible and get out.
Let's say we go through the process, Bill. I know you're involved quite a bit with jury selection as well. How do you do it, and what are your thoughts in terms of the process on it?
It's the worst part of my job.
Right.
It makes me absolutely crazy. And the reason why it's the worst part of my job is because the rules and parameters are different for not every single courtroom, every single judge.
Yeah.
And then you have state versus federal. I mean, I picked a jury last year in Cleveland, and I kid you not, the judge walks in, all rise, be seated, looks at the attorneys and says, okay, you got 30 minutes each for juries. And I'm like, 30? I've got 30 minutes. Are you out of your mind? And so that's puts me in a very difficult position, meaning, okay, I have to look for the top factors I'm looking for. And then in state court, oftentimes you're getting all day, if not multiple days. I think that's something, I think the best tool for jury selection that goes unutilized often because people don't think about it or they assume the judge won't go for it and they're wrong, is the use of a supplemental juror questionnaire. I can do some serious damage, and I can make this 2 pages. This could take 15 minutes to fill out, and that's what I tell the judge. But I can get some very sensitive information on a questionnaire I would never be able to get in oral voir dire, ever, right? Think about it. If during oral voir dire, no one's going to raise their hand and say, "Yep, I'm a racist," or "Yep, I'm a sexist," or "Yep, you discriminate against gays and lesbians." No one's going to say that out loud, right? On a questionnaire, you'd be shocked how honest people are. And you have a lot of cases out there which do have racial components, do have a sexuality component, and no one really wants to talk about that. I work in a lot of premises liability cases where people get raped, and the claim is that, hey, the security. Well, how are you going to pick a jury on a topic like that? Well, that's where your oral voir dire only gets you so far, and people don't like to share sensitive opinions out in the open. But on a questionnaire, you'd be shocked how much I can essentially expose on people because they don't have the public aspect of it, and they'll be far more honest on a questionnaire. And by the way, both sides want it. Trust me, the plaintiff's bar wants the questionnaire too, and you may have to negotiate on what questions are going to be asked, but that's something that really can be a huge impact on jury selection that doesn't get enough attention.
Well, and that kind of leads me to where you started on this topic, which is the control of the courts and the individual judges. You usually get receptivity from the court in terms of the questionnaire, or again, depend on the judge, depend on the case.
Yeah, it's really depending on the judge. But what your argument is that you're going to expedite jury selection, right? So what's going to happen now because of COVID, when things start to open up, it's gonna crawl. I mean, jury selection was, unless it's a federal case, jury selection is a very tedious process. Now it's going to be even more tedious because of, is social distancing going to be around forever? I don't know, right? Mm-hmm. Are they going to change the rules? Jury selection is going to take longer going forward. So your argument is, which has always been the argument, is the questionnaire is going to expedite the process because we're going to find out all this information very quickly in written form, and we don't have to rehash everything orally. It's that most judges kind of like that idea, but again, if you're giving them a 19-page questionnaire, they're going to look at you and be like, "No, that's not going to work."
You got to pick your shots.
Yeah.
Exactly. Just in conclusion, Bill, what do you see as in terms of what you're finding on the COVID civil unrest? What are you seeing from a jury perspective on that?
Well, we've collected data in 7 cities across the nation. We have a pretty good sample size, and we've also been doing a lot of online research, which I'm not a huge fan of, but we're kind of stuck with it right now because of public policy. We've still done actually some in-person mock trials and focus groups in certain locations where you're not in a COVID hotspot, and so we can social distance the mock jurors. You got a pretty emotional group, a very emotional jury pool. And it's quite frankly mostly politically based as opposed to COVID based. I mean, everybody is fair. Okay, I got to wear my mask, and yeah, people get over stuff like that. But yeah, there's a lot of people have been furloughed or laid off. I have a few friends that have actually had small businesses had to claim bankruptcy because they couldn't get their, so you have some definitely and people that have been sick or ill or had lost a family member from COVID. Yes, those issues are out there. That combined with the current political atmosphere, you have a stick of dynamite right here, right currently, and a potential. I mean, look at the craziness that you see in some of these protests, and I mean, this is what people are doing right now, and the courts really aren't going right now. They're on pause, and so I think a lot will be dependent what happens on November 3rd. Right. I think a lot's going to be dependent on where medically this goes with a vaccine. And is the country going to lower? Because the country right now has a fever of about 108 degrees. It's not 98.6, right? If we can get that fever to drop, I think that results in more rational and logical thought at the jury decision-making phase. If that fever stays up, I think you get more of that emotional decision-making like we talked about, and that's where things can get out of hand. But we have no control over these things. So I think whether you have COVID or not, vaccine or not, social unrest or not, companies, insurance companies, defendants can and should take control of a case early, be aggressive. And yeah, I think the big decision is, do we want to spend the money, right? Do we want to, it's not spending. It's the difference between price versus cost. Right. It's a price to something, but this is a cost. And the cost can actually come back in your pocket. Do we want to invest in preparing our witnesses effectively, accurately assessing our cases, or are we going to be reactive and let the plaintiff's bar take advantage of us? That's what it's really going to come down to regardless. But I do think come November, we're going to learn a lot more about jury decision-making and kind of seeing where the country goes as a whole.
Bill, two things. Number one, thank you very much, of course. Appreciate your time on that. And secondly, as a person who was at the last game at Carmichael, go Heels.
Heels. Thank you, Doug.
Thank you, Bill. Take care.